Welcome to Brief Encounters and a July episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong Teasdale, as well as leader of the firm's Securities Regulation and Litigation practice. And with me is my co-host, William Nelson.
Hi, Valerie. Yeah, William Nelson. I'm the Director of Public Policy and Associate General Counsel at the Investment Advisor Association.
And today we have a very special guest with us who William is going to introduce and who we're both very excited to speak with.
Absolutely, Valerie. Yeah, incredibly excited. We have Aaron Capel, who is the CFP Board's Managing Director of Government Relations and the Public Policy Council. And for full disclosure for our audience, I previously served in that position. I couldn't have picked a better successor than I got in Aaron. So incredibly happy to have her on the podcast today. Just as a little bit of background, Aaron does lead CFP Board's legislative, regulatory, and executive branch advocacy efforts and leads the public policy priorities. Prior to that role, she did also serve on CFP Board's Deputy General Counsel of Adjudication. Valerie, you're going to talk a little bit about the CFP Board's adjudication process today. Also, was a partner in the global law firm Candle Gates before coming to CFP Board. So again, just incredibly excited to have you on the podcast today, Aaron.
Thank you so much to both of you. I'm delighted to be with you today. I'm a fan of the podcast, and what an honor to be a guest on it.
And we're super excited for you to be here. I always find the CFP Board's role in the ecosystem of financial services really fascinating because CFP Board is a standard setting organization. You have a very large number of certificates at this point, but you also contribute actively to the public policy and advocacy discourse and thought leadership. So I'm just really excited that we can talk about all of these things with you today, Aaron. But I thought maybe we could kick it off with you giving us an overview of the CFP Board.
Yeah, thank you for that opportunity. CFP Board, as you mentioned, we're a standard setting certifying body. We're a nonprofit organization. And we, as the name suggests, the Certified Financial Planners Board, we certify financial planners. And there's approximately almost 110,000 CFP professionals in all 50 states across the country, as well as in various U.S. territories. And that is about 1/3 of all retail financial professionals at this point. And CFP professionals are affiliated with a number of different kinds of firms, or as we refer to them as business models. CFPs can be affiliated with broker-dealers, investment advisors, insurance companies. Some kind of work on their own as sort of pure financial planners. So we touch a lot of different regulatory structures and sets of laws, which is, I think, an interesting component of the work that we do. I'll mention that all CFP professionals voluntarily agree as part of their certification to our internal code and standards. So we have our own set of ethical standards, and the cornerstone of that is a fiduciary duty. So they voluntarily agree, pledge to adhere to a fiduciary duty, which means that they have to act in their client's best interests at all times when they're providing financial advice. And, we know that awareness of the value of working with a CFP professional is rising, which is driving the demand for more advisors to become CFP professionals. And our goal is to grow the financial planning profession to increase access for all Americans to competent and ethical financial planning. And so with that, as you mentioned, we are engaged in public policy advocacy efforts at the federal level, on the Hill, as well as at relevant agencies. And we're looking to build a more active policy voice for the profession. And we think that adds value to the certification for that almost 110,000 CFPs across the country.
Yeah, thanks, Aaron. That's an incredibly helpful. And, I know the great impact that CFP Board has on the discourse. Jumping off from there, we were hoping you could just maybe talk a little bit about some of your main public policy priorities, but also, I know you've also done some work recently around fraud. And we all know fraud just escalating so quickly, emerging technologies, crypto, artificial intelligence. We just see it everywhere now in the news. But I was just hoping you could touch on some of those public policy priorities, but also discuss some of that recent research, which I think is incredibly interesting.
Absolutely. No, I'm happy to do that. We're building a sustained public policy program around a variety of different priorities, but really focused on consumer protection, fiduciary advice, access to competent and ethical financial planning, and looking to, enhance the role of professional standards that are in our changing financial services marketplace. And so, we're really focused on the things that are going to advance the profession for the benefit of the public. One issue that we have been focused on quite a bit recently, and I would put it into the, category of investor protection and education, is the identification and prevention of fraud and scams. And so there's a variety of policy work that we've been doing. And to support that work, we have a very robust research department here at CFP Board that on a regular basis does research and survey work from both CFP professionals. So we've got this really great group of people, financial advisors on the front lines who we can survey fairly easily about issues that are kind of top of mind. But we also do on a regular basis consumer related surveys. And one that we did that came out just this past month in June was called Don't Fall For It, Guarding Against Financial Fraud. And we were really trying to identify, how folks are grappling with the relentless, barrage of financial fraud attempts and the challenge of detecting scams. And we know that losses out there are just massive and increasing on a yearly basis. I think it was 2025, the FBI reported losses from online financial crime of being almost $21 billion, which was a more than 25% increase year over year. And that's frankly just the tip of the iceberg. We know that financial fraud in particular is greatly underreported because people may not know it's even happening, but also because there's a stigma, there's an embarrassment there for folks who are often victims of it. And so we'd like to help with that issue. And so this survey was getting at some of the challenges that people are dealing with on a day-to-day basis. And that research showed that fraud is not a remote or a hypothetical risk. One of the key findings of the report was that more than 60% of respondents reported encountering fraud or knowing someone who had, and more than half of them expect that they or someone close to them will be targeted. So this is a central part of protecting household financial security. And the sophistication of these scams is increasing every day. Fraud attempts include phishing, smishing, imposter scams, investment scams, AI voice impersonation, deep fakes, things that we just really didn't even imagine existed even 5 or 10 years ago. And they raise all kinds of legal and regulatory stakes. And the other important thing too is that victims often, they don't even know where to turn. So one of the most important findings that we found is that, and it's echoed in other research out there too, is that many victims, they never contact anyone when something happens. They don't contact their bank or their securities firm or even law enforcement or family members. Some of them don't know who to call. Part of it is that, but others are embarrassed or fear the consequences of this fraud. So we see CFP professionals as being, if you will, financial first responders for their clients. So CFP professionals have a holistic view of their clients' financial life. They might be positioned best, really, to spot unusual activity, help clients create fraud prevention and response plans, and encourage people really to, oftentimes because these things are presented as being immediate or an emergency, is really just to slow down, to pause, to verify, and to report before money moves out of the account. So CFP professionals and other financial advisors out there really can be, the heroes in this, in preventing fraud from happening or from really going further than it needs to. And so our public policy engagement is focused on both prevention and victim support through a variety of initiatives that recognize that protecting consumers requires these like front end safeguards, but also better back end relief when fraud occurs. And I'm happy to get into those, but I'll pause there for a moment if there's any follow-up questions.
Yeah, I think for me, Aaron, I think that's incredibly great. And I know we've also at the IA been working on a lot of these issues. So I was hoping maybe you could talk about some of the legislation that's, going through Congress right now. And again, I think hopefully it's bipartisan, and we definitely want victims to be heard and to allow them that relief. But yeah, I was just hoping you could maybe talk about some of the bills that you're currently supporting, where we're fortunate enough to get to work in different coalitions with you.
Absolutely. Yeah. I mean, I think the biggest concept, William, for the financial services industry at the moment, at least to focus on, is the idea of these hold and report laws. And states have been really good about enacting these. There's a NASA model rule. The State Securities Regulator Association has come up with model rules on this that many states have adopted that permit or mandate financial institutions to temporarily delay suspicious disbursements and then to report suspected fraud or exploitation to the authorities. I think it's like half of the states at this point have enacted those laws. And we're starting to see recognition that this kind of protection and tools could be offered to the financial services industry on a broader level. And so there's one particular piece of legislation that I'll highlight. And I know, William, you at the IAA and certainly us at CFP Board have been supporting for a number of years. It's called the Financial Exploitation Prevention Act. And this bill recently, 2 weeks ago, passed the House with an overwhelming vote of 414 to 2. So strongly bipartisan, highly recognized, potential solution to some of this. That particular piece of legislation would allow mutual fund companies, so open-ended investment management companies, transfer agents, to delay the redemption of securities for a reasonable amount of time if they believe that a senior or a vulnerable adult is being financially exploited. And that can be extended where there's evidence of exploitation. It can go on a little bit longer. It also would require the SEC to evaluate and report legislative and regulatory recommendations to Congress about combating financial abuse on elder folks in our communities. And we see those types of laws as being really important tools for the folks, again, these financial first responders who are on the front lines at firms across the country to really be able to protect their clients. FINRA has been involved in this as well. They've got rules, of course, FINRA for broker dealers, the idea of these hold rules for firms to be able to use. And there's proposals out there now that CFP Board has weighed in on, many others as well, that would continue to provide firms with these tools and to enhance them. Also, the idea of trusted contacts. So the idea that you would identify when you open your account and then you would confirm on a regular basis someone who a firm could call, a family member, maybe a close friend, whoever the client might choose to identify, that can be someone to, potentially help find someone if they're not able to be contacted and help them deal with a suspected financial exploitation or fraud situation. We had recommended, in the comment letter back in March, that FINRA go even further with this. So rather than making it, sort of an optional kind of designation, we would say it would be an affirmative opt-out situation. So in other words, we would expect someone to designate a trusted contact unless they affirmatively decide not to do that. Of course, that would be their option, but that would at least mandate that the conversation be happening between a financial advisor and their client. FINRA has also proposed having a speed bump, if you will, a temporary time for all folks. So not just for people who are elderly or otherwise vulnerable, for anyone where there's a suspected issue in an account, that they'd be able to put a brief, it's been proposed to be 5-day speed bump or hold on an account while something is investigated. And so we see these as being really effective tools that we'd like to see implemented on throughout the industry, whether it's investment advisors, broker dealers, other kinds of financial institutions, because they are proven to be important tools. And they're really, as you can see with the Financial Exploitation Prevention Act, very broadly supported bipartisan initiatives. Another thing that I'll highlight too that we've been working on is assistance for victims of financial fraud. There's actually an interesting scenario that folks can find themselves in today where if you've been defrauded out of money in your account and it's not a very narrow kind of investment fraud like a Ponzi scheme, that you might actually have to pay taxes on those losses. There used to be, prior to the Tax Cuts and Jobs Act back in 2017, there used to be a deduction for that for folks. That was temporarily suspended during the TCJA and then made permanent recently with the One Big Beautiful Bill Act. And we're working with a number of offices to try to bring back that deduction. There's two bills that have been introduced in Congress that would do that. One of them is the Tax Relief for Victims of Crimes, Scams, and Disasters Act. That's bipartisan legislation. And there's also another bill, the Tax Relief for Fraud Victims Act, which was introduced in the House by Representative Max Miller and recently was approved by the House Ways and Means Committee with a unanimous vote that happened just about 2 weeks ago, that would also restore that deduction, and also that bill would protect retirement accounts. So we're seeing some movement towards potential solutions in that area, but so much more to do to protect folks from fraud out there.
No, I think that's exactly right. And, I'm listening to all of the different pieces you've described, Aaron. And I think back to 2014, 2015, when this dialogue was really kicking off. I remember like FINRA put in place its seniors hotline very early on, even as sort of the different rule structures were coming online. There was the NASA model, there was the FINRA proposal. Then the FINRA rule, that was the product of the first proposal, was eventually expanded later through a later proposal. But through all of this, there's always been this issue of how can somebody who is a victim of fraud or suspecting they're a victim of fraud, what are the first lines of resources that they can have? So I really like this idea of financial first responders because usually people's brokers or investment advisors can have a close relationship and be somebody that, a senior can turn to. The FINRA hotline was another sort of same concept, right? That anybody could call in and get support on next steps. But I think all of that has expanded over the last 10 years in terms of additional legislation, additional initiatives, and it takes multiple regulators and organizations coming together to make this happen. This can't just be sort of one entity that does this.
Yeah, that's part of the challenge, I think, here is oftentimes, there are multiple regulators, there's multiple sets of laws that are implicated in these kinds of frauds and scams. And those regulators are not necessarily talking to one another. And so there's a couple other bills out there that we've supported. One of them would be like the TRAPS Act and some others that would try to bring these regulators together to have these conversations. We know that they're trying to do that, and we applaud these agencies for doing what they're doing. It's a tough situation, but making sure the right people are in the room to be having these discussions and to try to make meaningful progress and to take action towards a solution for this, incredibly important issue that we know is so vastly underreported that, when I say losses are, reported to be totaling $21 billion, I mean, it could be multiples of that, that are actually happening to folks out there. This is a really important issue for people to be grappling with.
Yeah, absolutely. And, on that note, I was really glad to see recently that the SEC has reinstituted the retail fraud working group internally. It was initially announced, I know, by the recently appointed director, Woodcock, back in May. But I am glad, Aaron, to your point, that regulators, I think are really aware of this issue and are looking at different ways to attack it. But also on that note, we did recently receive the SEC's regulatory flexibility agenda, basically the list of rules that they're potentially working on over the next weeks and months. A lot of it is focused on modernization, innovation, when it comes to things like electronic delivery, other issues like that. But the CFP board also there was a recent rule that would potentially move the reporting for public companies from a quarterly cadence to semi-annual. So I was hoping maybe if you just wanted to touch on your letter, but also maybe any comments you had just on the regulatory agenda. I know Valerie has coined the term the Atkins avalanche. We did see a lot of rules on the agenda. So just curious to get your thoughts on that.
Yeah, well, I guess first on the Reg Flex agenda, we agree. I mean, I know that Chair Atkins had said at one point that he was expecting to propose 30 rules this year and another 30 next year. I didn't count the number of entries on the agenda, but it sure seemed like we're getting to 30 pretty quickly. It'll be a packed agenda and quite a lot for those in the industry and certainly the lawyers that support them to be keeping track of and to deal with. We're closely watching, those proposals that pertain to investor protection and advice standards, access to various investment products and advisor regulation. We too were very pleased to see the formation of the working group that was announced formally just a couple of days ago, because certainly, we agree that protecting everyday Main Street investors from malicious financial schemes and fraud is really the most critical thing for the SEC to be doing for sure. On the proposal that you mentioned, William, that would move from mandatory quarterly reporting to semi-annual reporting for public companies, we took a strong position against that proposal. My understanding is that the vast majority of comments that were received by the SEC would fall into the camp of opposition. I'm sure there was nuance there as well among those comments, but we were troubled by the idea that there would be less frequent reporting. We think that'll weaken investor protection and transparency. And specifically what we mean by that is widening information gaps, particularly for folks who are retail investors. Institutional investors are going to continue to be able to access information because they can pay for, alternative private data streams to track a company's health. But everyday investors rely heavily on these standardized public disclosures. And we also feel that it'll have a direct impact on financial advice that folks like CFP professionals are providing to their clients, because they also rely heavily on this steady, standardized financial baselines to be making prudent, long-term financial planning recommendations for American households. We're also concerned about the idea that the move from a predictable quarterly check would impair the detection of fraud and impact corporate accountability by just making it harder and to take longer to discover, more systematic problems and things like insider trading. And then the other issue too that we saw being important to highlight to the SEC, and we did so in our comment letter, was, the idea that it'd be difficult for folks to compare. You might have a group of companies that are continuing to file quarterly reports because they choose to do that, or there's another requirement, through a contract or something like that for them to have to do that. And then others that are reporting only 3 times a year, through a semi-annual 10S form. And, that would make things harder to compare. You're no longer doing an apples to apples comparison. You might be doing an apples to oranges comparison. And that just makes it a whole lot harder for people to try to make decisions on what investments might be best for them.
Yeah, and those are all great points there. And I know the IA also generally opposed, while we always appreciate modernization and updating rules, we kind of fall along the same lines about, we definitely want those kind of transparent, consistent disclosures, especially for asset managers who are, obviously helping clients manage money. And we really want to have that stream of information. But Valerie, I don't know if you had any thoughts, either on the Reg Flex agenda or otherwise.
I'm glad it came out. I know we were all waiting for it and we wanted to see how extensive it is. I do think, there will be a lot of rulemaking, hence the term the Atkins avalanche. I also think that this is really about modernizing rule books. There's been a lot of questions on whether it is deregulatory, and I just don't think so. I think it's more about evolution and modernization and sort of what comes next for the industry. There's definitely rules that do need to be modernized. And I think Chair Atkins is certainly taking that to heart with how the Reg Flex agenda is being shaped. I know that we're starting to run out of time with you, Erin. So we've talked about policy priorities, thought leadership, a lot of the advocacy and research that CFP board has put out. Is there anything else you wanted to highlight?
No, I appreciate that, Valerie. I mean, the only other thing I would mention, I think it's sort of related to what we were talking about with, the research on fraud and CFP board getting the word out that, CFP professionals like other financial advisors can be this financial first responder. I think in a similar vein, we're focused on financial education and literacy as well, supporting state high school requirements for financial education semester long classes. But also, with the administration's rollout of the Section 538 Trump accounts, we see CFP professionals as being important educators of those too. What do those accounts entail? How are they different from other accounts out there that parents might be considering for their children? And so that's sort of illustrative of the idea that, CFP professionals really are, again, partners with American families across the country and how they can help them sort through this, what at least appears to be super complicated, right? Array of things that you need to sort through to try to make these financial decisions for your family.
No, I think that's exactly right. Something else, sort of, because we try to often take a practitioner point of view in these podcasts. So, something else I also wanted to flag is obviously the CFP board as a certificant association and standard setting organization. You also have an enforcement function. And that's something that, whether it's a registered representative or an investment advisor representative that is also a CFP member, if a registered individual that is also a CFP certificate, rather, has any kind of resolution or settlement with a regulator, whether it's, the SEC or FINRA or state, there can be collateral consequences to their CFP certification.
Yeah, that's right, Valerie. I'm happy to talk about that. I mean, it's true. And as a former defense lawyer myself, I appreciate this idea of collateral consequences. Our standards, our code and standards, the rule book that CFP professionals are required to adhere to require CFP professionals to report certain kinds of, if you've been charged with a crime, for example, if you're the subject of a regulatory investigation, then of course, the outcome of those kinds of things. Those are things that need to be reported to us within a certain time period. There's also monitoring that CFP board is doing, that staff does of, for example, broker check, IAPD to see, what kinds of things are being reported on someone's CRD. And those things could end up being the subject of an investigation at CFP board and a potential action being brought against someone. We have a very robust process for that. There are procedural rules that outline how those investigations and how those proceedings will be conducted, how the adjudication of them will go. There's an appeals process as well. But it's certainly something I think for folks who are in particular representing individuals in regulatory investigations at the SEC level, FINRA, also at the states, of course, as well, should be aware of when they are considering the, potential consequences of something for their clients.
That makes a lot of sense. And it needs to be part of the collateral consequence analysis for any individual who is also a CFP certificant. William, did you have any more questions for Erin before we wrap up?
No, I don't think so, Valerie. Other than just to say again, thank you so much, Aaron, just for all the great work CFP board is doing. Again, as an alum, I always appreciate the growth and the impact you have on the industry. So thank you again for being on the podcast today.
Yes, thank you, Erin.
Thank you so much for having me. It was a delight to be with you, and I hope everyone has a great day.
Thanks again, and to our listeners, till next time.